Baltimore City Council Ways and Means Committee, we are back in session for City Council Ordinance 22-0235, Ordinance of Estimates for the fiscal year ending June 30, 2023. I'm Eric Costello, Councilman for the 11th District, Chair of the committee. I'm joined to my far right by Councilwoman Odette Ramos, 14th District, and to my far left, Councilman Ryan Dorsey, 3rd District member of the committee. To my immediate right is Marguerite Curran, staff to the committee. Representing Mayor Brandon Scott, Nina Themlis, and representing Council President Nick Mosby, Nate Poole. We are here for BMZA, or Board of Municipal and Zoning Appeals, BMZA. Ms. Byrne, you have one slide?
I do.
Excellent. So what we're going to do is I'm going to turn it over to you. I'm going to ask you to introduce everyone on your team that's here today, first, last name, and position title. Ask you to go through your slide in 3 to 4 minutes. The three of us are all very familiar with your operation, and then we will jump right into questions and answers. When you are speaking, please keep the mic about one hand length away. You will inevitably forget to do that or screw up at one point, and I will politely interrupt you to do that. You'll probably do it a second time, and I will politely interrupt you again. With that, let's get started.
Okay. Thank you. Katie Byrne, Acting Executive Director on behalf of the BMZA. One person with us from our staff of 5, and that is Rebecca Witt. She is our Assistant Counsel. She joined us in January. We're super excited to have her here. She came to us from Community Law Center, I think 9 years at Community Law Center. So it's a great addition for us here at BMZA.
We're happy about it.
Looking at our slide in particular, I think, as you said, pretty much everyone up here knows what the BMZA does and how we function. Our numbers for 2020, 2021 obviously were impacted by COVID. We did all of our hearings in 2020 and 2021, actually starting in May of 2020 all the way through March of 2022 were all virtual hearings. And during that time, we had a number of appeals that were reduced because people essentially just weren't filing appeals, and it took us a little bit longer to do things virtually. We are back in person now. So the targets for 2023 are hopefully reflective of what it will look like when we have more cases coming through. Let's see, some of the things that I would point out, we had to make some changes. So the average number of days from public hearing to written resolution, it's been extended a little bit. And the reason it's been extended is because we had a remand from the circuit court. And there's been some changes in case law. It says that the board now must formally adopt resolutions. Before the board would deliberate, resolutions would be drafted, they'd be signed, we'd be able to turn them out. Now we actually have to bring the resolutions back on a hearing date. So that's going to add about 2 weeks from the time that a resolution comes out. So those are just some of the tweaks in our performance measures, really are based on what we anticipate cases coming in and some changes in procedure that we've had to do because of case law that's come down from higher courts in Maryland. As far as our budget goes, it's pretty much exactly the same as last year. It's increased because of certain costs that have gone up, but other than that, we're on target to move forward with what we have. So if anybody has any questions for me.
Mm-hmm. Thank you, Director Byrne. Really appreciate your time today and all that you're doing. I have a couple of questions, and then I'll see if my colleague has any questions. You mentioned this issue of the timing, which is one of the, I didn't understand what was in the budget book, but you explained it, where they, now you have to bring it back to a hearing date
right.
in order to get the vote for the resolution.
Right. So it's the way that it normally works is, and you've been to plenty.
Yes.
So you see the board, here has the hearing. We're now doing deliberations immediately after, which is another change from some
Yes.
case law that we've
like
heard
that
about.
too.
So they're deliberating right after you're getting that decision. The executive director is responsible, along with the associate counsel, for creating that resolution, for essentially drafting the board's directive per the deliberation. Before, we would just memorialize it. The executive director would sign it. It would never go back to the board. So what we're doing is it has to go back to the board. So the Court of Special Appeals essentially said that the board needs to affirm that this is what it meant, right? Because say you have a variance, you have to identify uniqueness, you have to identify hardship, and there are specific facts that the board pulls from the record, and they're like, yeah, this is why it was unique, or yeah, this is why it was a hardship, and this is why we're going to grant it. So the board needs to affirm that we've put those right factors in. So particularly for the contested cases. So we're doing that now in the general meeting. So you'll notice when you look at the agenda, 12:30, we added another line under miscellaneous. So now we have adoption of resolutions. And this is where I go through, they each have the resolution, they get them ahead of time. If they have any questions or they're like, no, that's not what we meant, then they can change it and edit it.
Right, and that seems to make sense, but then it also, the clock for appeals of the appeal, basically, any reconsiderations takes another 2 weeks.
It does, it does. So what will happen is, it'll take another 2 weeks after it's signed, then someone, for a motion for reconsideration, it's 10 days. So if that motion for reconsideration is put in 10 days, then it could be another 2 weeks to 30 days for the board to rule on that motion for reconsideration, and then we'd have a final decision, and then there could be an appeal to
Right.
circuit court.
Well, I think from a public standpoint, it's helpful because then people can mobilize and think about things, et cetera,
Right.
rather than everything being pushed through. So I think it makes
Right.
sense. It's not really helpful for you all because you have administrative steps to go. But it has been
Yeah.
helpful, I think, for us to, the process has actually slowed down a little bit.
Yeah, yeah, and and the other thing that I think would be a good function is pretty much all the resolutions will be issued on the same date. So if the hearings so we have a hearing tomorrow, so all of those resolutions will be generated on the following hearing date or the hearing date after that. So it will be within X number of days of that hearing date, and they will all have the same date. So if you're tracking things on a regular basis, you're like, okay, I know this has to come back. It hasn't come back yet. So I know when it comes back, it'll be 1 or 2 days after, it'll be signed, uploaded, and then I can prepare.
Right, okay. And then I saw on the targets, you did lower the number of days between public hearing and resolution, but it seems like that might not be, you don't want to lower it, you want to increase it. 'Cause you
So
wanna
that,
have more
yeah,
days.
for targets for 2023, that's definitely what, let's see, for the ones from zoning appeal to public hearing has increased a little bit, and like 90 days, the reason why we had a target of 90 days for 2022 is because I didn't have any bodies. So I knew it would take me
Oh, okay, so this is
physically
separate.
longer,
Gotcha.
right? It's separate. So
Yeah.
2022 is a different factual scenario for
Got
us
it.
because it was just me. But now that we're fully staffed, that will be a normal turnaround time, should be 45 days.
45 days, okay.
Exactly.
Great. We're joined by Vice President Middleton as well. Okay, Councilman Dorsey, did you have any questions?
None.
Thank you, thank you. Did you have any questions for zoning?
Yes, I think I have one. Hi.
Hi, how are you?
Good. So, we have areas of the city, I don't know if you covered this, so I apologize if you
okay.
asked it, but we have areas around the city that, are getting drug treatment centers. And, I guess we call BMZA to see if if there's a potential one coming, because people in the community, they get information and they call our office and want to check to see if there is one coming in a shopping center or so on. Are you the agency we call to try to get that information?
No.
Okay.
So that would be the zoning administrator. Anything that comes before the BMZA has to be public, is going to be a public hearing, and it would have to be posted. So community would know if something is coming. And in the zoning code, there's a definition for residential care facility, and there's a number, right? Residential care facility greater than 17 people, residential care facility under 17 people. And they're allowed in particular zones. Sometimes you have to go to the board, sometimes they're permitted outright. But you always have to go to the zoning administrator for your permit. So if someone has applied for a permit for a residential care facility and it's not something the zoning administrator could issue as of right, then it goes up to BMZA. But public will always know if it's before the BMZA because it has to be posted for a public hearing.
Okay.
Now, it won't say drug treatment center on the sign.
No.
And this is where, this is part of, and we're working with planning on community outreach and PowerPoints to really to explain what the BMZA is and what it does, because it is confusing. It is confusing as what's the zoning administrator supposed to do? What's BMZA supposed to do? What's planning's role? Like, we all touch it at some point in the process, right? And it's hard, and it's not one versus another, depending on where it falls. It, the zone, Jeff could send it upstairs to BMZA because the code says, hey, it's conditional use. You got to go to BMZA for approval. If it doesn't have to come to us, we never see it. Sometimes some things have to go through planning commission. Sometimes there's an overlay that they have to look at. But permits are always issued through DHCD, and the zoning administrator will look at every single permit that comes in. I think there's like something like 40,000 permits a year that come through. He will look at every single one. So again, jumping back to what I was talking about, that sign, if anyone sees residential care facility, that's when you can call and find out what it is. So if anybody has any questions about a sign that they've seen, they can call our office. If we have information, we'll gladly give it. They can get copies of any applications that have been submitted. They can also call the zoning administrator's office. You can also go online to DHCD for permits, and if you click on that permit application, a lot of times in the narrative, they will say exactly what it is. They won't just say residential care facility, they'll say inpatient drug treatment, or they'll say assisted living, or they'll say nursing home or something like that for seniors, and a lot of times they give the exact care.
I know that there's been a problem, at least in Northwest Baltimore, because of the large homes and so on, and there was, we were trying to work with the state to add some language that they have to be a certain mile radius, so we don't have a whole bunch of them in one area. Do you help to work to deal with that with the state? Or who do we go to get that rolling
Right, so
on the city end, on the city side?
with my BMZA hat, no. That is, so if you think about BMZA as the judicial branch of the 3 branches of government, right? Our board members hold a public hearing. They have the law that they have to apply to the applications and the facts that come before them. They don't make any policy decisions. They don't make any specific determinations. They look to the council and to the zoning code to essentially tell them what it is that they can or cannot do. So if you think about the BMZA as the judicial branch, they don't necessarily get involved in that. Whether or not you can have the distances, that would be more my DHCD hat, and that would also be a law department call as well, because then you're talking about potential changes to other code sections where the BMZA doesn't necessarily, they don't get involved in what the code says. They just only apply it.
Okay.
If that's helpful.
Okay, thank you.
And Madam Vice President, my office and Director Byrne and a few others in the law department have been working on a specific piece around the group home, which is slightly different than residential care facilities.
It is.
So, because residential care facilities there's some care given at that facility, as opposed to the group homes where there's no care given at the facility. They're just there to then participate in programs, et cetera. So, at least in my district, that's really been the issue, is where there's no care being given, and so there's no regulation, there's nothing. We did get a ruling at some point that you can't do distance between because it's a fair housing issue, because they're treated as single-family homes. But you'll see I don't know if it's coming from the mayor's office or from my office, where they'll be having a way to sort of make sure that all the building codes are followed and everything else on those properties as a way to try to address it. So it's a complicated issue.
It is, it is.
So-
It is. And but I understand when you're talking to community, they're like residential care facility, group homes, all the same. Why can't you do something about this?
Yeah.
But it's not. Like, that's the hard piece. It's not.
Right, so there's so many nuances in that. We could
There
have
is.
lots of hearings about it. So,
Yes.
yeah, but thanks for bringing it up. I
Thank you.
appreciate it. And I don't have anything else. I just want to thank you and your team for doing really a great job. I mean, sometimes you're there a lot of hours. It's really complicated. But I also want to thank you for whenever I've had questions, just kind of walking me through so my predecessor was an expert on zoning. I'm not. And so it's been very helpful to have your guidance on as we work through some of these really complicated things that are happening in my district. And so I really appreciate the time you're taking.
Sure,
to
no
help me out
problem.
with that, for sure. So anything else? He's
I
gonna
do have a
question
question.
anyway. Go ahead.
It's really not budgetary related. So
It's at 1:30, yeah.
I just
Thank you.
kind of have been repeatedly kind of perplexed about the limitations of the BMZA to interpret certain things.
Mm-hmm.
They're as ambiguous or open-ended language in the code
Right.
that refers to things like the potential for a thing to have an adverse effect on other things around it.
Right.
And like, is there some standard for determination of like what's reasonable to consider? For example, I have a lot of concerns about auto-oriented development, car-oriented development, and the potential for it to have an adverse, not just the potential, but the wealth of research and evidence of its adverse impact on walkability and Main Street kind of conditions, and that it has the capacity to even deter investment and the growth of value of neighboring properties, or even its own property, right? There's extremely low property value to many auto-oriented uses. There's like no lower value of land than like a surface parking lot, for example. Is there some statutory extent to which a board member or board members could say, there's this body of evidence that says this kind of development would have an adverse impact on this, even if it's not in the status quo of considerations?
So probably where you're leaning more towards are conditional uses.
Mm-hmm.
So a conditional use in the code. So for example, a drive-through for a fast food restaurant.
Mm-hmm.
So the restaurant could be permitted in the underlying zone, but then the drive-through could be a conditional use. So conditional uses are deemed approvable unless, like as you said, the board finds that the use itself over and above just the normal
Director, can you
use.
hold the microphone a little?
Oh,
there you go.
sorry. I am a hand talker, so I would do the best I can to hold
That's
it
what you
here.
got to put the mic in the other hand
Right.
and use
Oh, you're right. You're 100%
the talking
right.
hand.
That's
has
true.
got to be the not mic
Right.
hand.
I will see what I can do. So for conditional uses, right? So it says it's deemed approvable. And the use itself, even though the drive-through is deemed approvable, so that means that the code has anticipated there will be increased cars, there will be increased traffic at this particular corner. But at this particular corner, is that effect over and above a normal drive-through? That's what the board has to make a determination. So they look at, and there's 12 different criteria in the code that they will go through and that they'll take a look at. So it's almost like an over and above standard. And it has to be site specific.
Right.
So I think that's the hard part. And that's where everybody kind of has to bring their A game. Now, I will tell you, one of the things that we've done as a policy decision is that if you need a traffic study, we're not going to hear your appeal until you go to DOT, until DOT comments and brings something back. Because I think in the past, and it's almost a chicken and an egg argument, right? Some people don't want to put their application in if the BMZA is not going to approve their conditional use, right? So then they'll take their chances to spend the money on a traffic study once the BMZA approves it. But then sometimes you don't know what that adverse effect is over and above until a traffic study's been done or DOT can weigh in, right? So the idea is that when you come to the board, you have everything. DOT has weighed in, you have your traffic study, you're identifying is what the adverse impact of this use potentially could be. So it is very much site specific, but there are cases out there and there's code statute that talks about how that should be measured and that it's over and above the normal use at this location. Now, I will tell you, we do have certain code sections where the business, in order to get your conditional use, and I want to say it's C1, it's neighborhood dependent, it's walkability. So if there isn't walkability for this neighborhood commercial use, then you don't get it, right? Because neighborhood commercial uses are just that, for the neighborhood, and the identity is to be walkable. And we've had the board recently deny a neighborhood commercial use because it was for tag and title. And they're like, how is that a walkable use for the neighborhood, right?
So, okay, that's a good,
Does that make sense?
yeah. So if a C2 property were directly next to a C1 property, and the intention of C1 is walkability, and the a given C2 use were to be of a sort that had a known adverse impact on walkability, is that within the scope of consideration?
It's something that the board could consider, the location, but the underlying zone is the underlying zone, right? So
Yeah.
if it doesn't count walkability as a criteria for that particular conditional use or that use, then the board doesn't have to consider it. But the impact that this use could have on immediately adjacent properties, the board could consider.
Thank you.
Okay, great. Madam Vice President, do you have anything else?
I'm good.
Okay.
Thank you.
All right. Thank you very much, Director Byrne. Really appreciate you and your staff, and thanks for your time today.
Thank you.
This committee is in recess until 1:30, when we will hear from the Department of Housing and Community Development. Thanks.